all to our virtual international conference on celebrating the 50 years of the independence of Bangladesh. And we'd also be celebrating our 50 years of the Constitution next year as well. The purpose of this international conference is to give a platform to early career researchers, PhD students, and academics from Bangladesh and abroad, so that they are able to showcase the very extremely important research that they are undertaking at the moment. And this international conference is jointly hosted by the South Asian Institute of Advanced Legal and Human Rights Studies, SAILS, Bangladesh Legal Aid and Advanced Trust, BLAST, and the University of Asia Pacific in Dhaka, Bangladesh. The segment of this section of the conference is Rights and Remedies under the Constitution. As you know, that we are celebrating the 50 years of our independence, and we have made giant strides in the economic front. However, a lot is desired in regards to the various human rights issues, personal liberty, and gender equality, and all those important issues as well. We have not been able to make the progress that we would like to make as a country. And it is also important to note that although we'll be also celebrating the 50 years of the ratification of our Constitution, the rights and remedies that we actually are allowed to get under the Constitution is not being followed as we want. So taking all those issues into account, we are extremely lucky to have two young researchers, Salwa and Takbir, who would be presenting on two very important areas. Salwa would be presenting her paper on digital evidence and how the current Digital Evidence Act that we have, which is a colonial era relic, just 250 years old, but has not been changed, should be changed, and what digital evidence or digital issues need to be incorporated into the act. While Takbir also talks about a very important issue about the Road Safety Act and how the compensation mechanism needs to be developed in order to protect the rights of people in general. And we're also extremely lucky to have three important and three very eminent panelists amongst us. We have Professor Manan Ahmed, Professor Aziz, and Professor Dina Siddiqui with us. And we also, just to give you a very brief background of a presenter. So Professor Salwa is a PhD candidate and adjunct faculty at Media, Culture, and Communication Department at NYU. Her research engages with theoretical frameworks for media studies, legal anthropology, and political theory, and a doctoral dissertation examines how the intersection between law and the digital sphere is a site where power is both reinforced and contested. Her research focuses particularly on digital evidence, the construction and operation of digital databases, and legal research software. Salwa has an MPhil from NYU and an MA in South Asian Studies from Columbia University. She also has a BA from the University of Washington with a double major in communication and honors. Takbir, he graduated from SOAS under the University of London and is currently working as an advocacy lead in gender justice and diversity at BRAC. He also worked as research specialist at Bangladesh Legal Aid and Services Trust BLAST, the country's leading human rights organization, and lectured part-time in various universities in Bangladesh. He also worked as a consultant with International Labour Organization, ITC, Equality Now, and BRAC University's James P. Grant School of Public Health. His research interest pertains to equality and tort law, with specific focus on strengthening the enforcement of compensation law in Bangladesh to bolster good governance and social justice. So without further ado, now I kindly request Ms. Hawk to give her presentation. Ms. Hawk.
Hi, everyone. Thank you. Let me just share my screen. Can everyone see this?
Yes, we can see it.
Yes, we can.
Okay, perfect. Okay, so thank you so much for the introduction and for having me here. So I'm Salwa, and my talk today is titled Plural Imaginations of Law, Evidentiary Process and Justice, Alternate Epistemologies and Marginalized Standpoints. And I know it's wordy and longer than necessary. We have to capitalize on catchwords, for the search engine. I'm sorry about that. But much more simply put, though, I explore how non-state courts in Bangladesh can sometimes lead to equitable outcomes for women that are often overlooked. So I analyze how alternate legal systems help understand the shortcomings of the rule of law of the modern nation state. So in Bangladesh, there are primarily two legal systems: modern state courts that are influenced by the British common law since the nation was under British colonial rule, and non-state courts, more commonly known as shalish, that are popular on the ground, especially in rural areas. And they've been in practice prior to colonial rule. Now, usually most international organizations such as the United Nations Development Program or Human Rights Watch or Amnesty International, as well as Bangladesh's urban elite groups, tend to regard shalish as too Islamic or backwards and, in general, harmful towards women. And so there are many global and local projects to reform shalish through awareness campaigns and other plans so that it adopts progressive laws and practices. I feel like there's much less conversation on how shalish can grant more equitable outcomes for rural women in certain types of cases than modern state courts. I focus particularly on how shalish handle digital evidence in family matters such as marriage and divorce. And my project has a mixed methods approach. I use ethnographic fieldwork. I observed around 31 shalish. I worked closely with the BLAST and Madaripur Legal Aid Association. I conducted archival research and interviews as well. So before we proceed, we have to understand Bangladesh's state law and the Official Evidence Act of 1872. Now, this act was initially conceptualized and implemented during British colonial rule and currently has provisions for oral and documentary evidence. As of now, the law has not been amended to include digital evidence, and in many instances, especially in family law, digital evidence are considered inadmissible in court. Shalish, on the other hand, aren't bound by the Evidence Act or any state law, so they can readily accept digital evidence in their legal proceeding. But it's not only this accepting of digital evidence that I'm interested in. I'm more interested in how this use of digital evidence in shalish visibilizes the shortcomings in the evidentiary process of state law itself. And that includes questioning the weight placed on factual documentary evidence, such as official documents. So let's try to explore this with an example. How do you prove a marriage, right? So most of you here would probably immediately think a marriage certificate, right? Which is known as the nikah nama for Muslims, or more commonly referred to as kabin nama in Bangladesh. Now, just imagine you don't have that, right? Now, this is a real issue for women in many rural areas in Bangladesh. Sometimes couples get married according to customary ritual without getting a kabin nama, or sometimes women think that they signed a kabin nama, but it was actually fake papers that the man made her sign. Or maybe the wife can't find the qazi that registered the marriage, who's probably in some other village, or she doesn't have access to the kabin nama because it's with her husband and he's refusing to give it to her. If you're the women in question, then how do you prove that you're married? So many cases in the Supreme Court suggest that if you don't have a registered kabin nama, that is, if you don't have evidence to prove your marriage is registered with the state, then there's no evidence to prove you're married, at least in court. Now, that's a very rigid state-centric response, but it is the dominant response in urban centers. There are comparatively much more fewer cases in the Supreme Court which argue that the kabin nama is not the only means of establishing a marriage. And these kinds of cases claim that all marriage and divorce for Muslim couples in Bangladesh are under personal laws, and Muslim law has alternate means of establishing a marriage, which is equally valid for Muslims in the absence of a kabin nama. So some types of alternate evidence are having children or living together or cohabiting, seeing whether the community accepts the couple as husband or wife, or more obvious witness testimonies. Now, these forms of alternate evidence are usually not prioritized in urban state courts, where the Qabinnama holds precedence over all other forms of evidence. However, in Shalish, these alternate means are very popular to validate a marriage in the absence of a Qabinnama. I argue that Shalish's non-doctrinal and flexible approach allow them to incorporate things such as digital evidence more readily, to the point where things such as text messages can be used to prove a marriage. Now, this practice usually benefits women who have, very restricted means to generate evidence to prove marriage, and that can be due to social, gendered, and structural inequalities and barriers. So again, let's go with an example to really flesh out how this happens. So in a case I observed in one Shalish, a couple, let's call them Shujan and Paki, had an affair and got married in secret. Now, Shujan didn't want to tell anyone until he was financially stable, but Paki wanted to tell her family and start their shangshar or married life. He refused. One day they had a fight, and that escalated to the point where, she told her family that she's married. Shujan was so angry with her that he stopped communicating with her, like all communications, like he just stopped it. So a Shalish was called from Paki and her family side to mediate the situation and reconcile the couple. Now, both families and guardians were there, community leaders were there, religious figures were there, local elites were there. And in this Shalish, Shujan admitted that, they had an affair, but claimed that they were not married, and there was no Qabinnama as proof. Paki claimed that she had signed papers, and from the local knowledge and statements and nonverbal cues of the participants, the Shalishkars, who are the group of people involved in the decision making in Shalish, they quickly realized that Shujan tricked Paki and made her sign fake papers. So the Shalishkars first asked Paki whether they had any children. She said no. Was she pregnant? No. Did they cohabit or stay together for an extended period at any point of the relationship? No. Does she have contact information of his friends who were witnesses? No. The number and location of the Qazi? No. So according to state, the rigid state-centric view, there's no evidence to prove the marriage since there's no Qabinnama. And even according to the dominant practices of Muslim law and, these alternate evidence, there's no evidence for marriage here either. And so, Paki then, when all other paths were kind of blocked, she opened her phone to show the text messages and Facebook chat messages that Shujan sent her, and that kind of showed that he treated her as his wife. In one text from the night that they eloped to get married, Shujan wrote in Bangla, and this is my translation, waiting until when I can call you my wife. In another text, he threatened to divorce her because he thought that she was flirting with another man. So he says, talk to the other person you're having an affair with, I will divorce you. Now, Paki shows these texts to the Shalishkars, and then she says, if I'm not his wife, then why is he saying that he will divorce me? Why did he say that he can't wait to call me his wife? This is proof. What other proof can I provide? Try to understand my situation. The Shalishkars concluded that the text messages and Facebook chat messages were valid evidence to prove their marriage. Now, why is that, right? It's because the logic is it proved Shujan's intent and promise to marry Paki. It proved the intimacy between them, the kind of intimacy that only husband and wife share. The logic is, even if they were not married under state law, the text messages proved the reality or bastobota of their relationship. It proved that they were married under the eyes of God, since there was evidence that he intended to marry her at a specific time, that the event had happened, and then from that day on, he did treat her as his wife. And so we see Shalish accepting evidence for marriage that isn't as common even within Shalish to prove a marriage. So what makes them be flexible and adaptable like this, right? So I argue that it's their approach to investigate the reality or bastabota of an event rather than gathering facts like the evidentiary process of modern state courts. So what's the difference between the two? A fact relies on, well, this is from certain schools of thought. There are debates from, but from STS and post-colonial studies, a fact relies on empirical evidence and tied to particular standards and epistemologies of modern science that rely on practices such as observation or experimentation or expertise and has a generalizability component to it. But reality can be something that doesn't necessarily need empirical evidence to back up its existence. Now, both fact and reality might not be representative of universal truth. Science and technology studies scholars have shown how the construction of a fact is not neutral and how they're usually produced from partial knowledge. In a similar vein, feminist, post-colonial, and decolonial scholars demonstrate how realities are socially constructed and realities vary depending on people's backgrounds and positionalities. I'm not here to debate which approach is better. Rather, the point that I'm trying to make is that Shalish's approach to investigating reality rather than facts allow them to incorporate certain kinds of evidence that might not have hard empirical data to back them up, and that can help women. Another point to note is that scholars who study the development of Islam in Bengal explore how its framework and practice include spaces of flexibility and ambiguity. I always have a hard time with ambiguity. And, that might have, influenced the practices in Shalish. And that's not to say that Shalish is an Islamic court. It's not an Islamic court, but it might be influenced by some aspects of Islamic thought and practice. So going back to the Pakhi Shujon case and using text to prove a marriage, I wanted to point out a comment made by a school teacher who was one of the Shalishkars. So he says, Pakhi has said a valuable thing. What other proof can she provide? She's just a woman. Men and women are not the same. We have to consider that while we're making our decision. Now, if we kind of deconstruct this for a bit, one take of this view is that it demonstrates the prevalence of patriarchy, right? The normalized and problematic assumption that men and women are not equal in society. But a more nuanced take also implies that this view might not refer to women's inherent unequal position, but rather their socially constructed unequal positionality. In this view, there is a recognition of the structural asymmetry of power, the gendered social context and power imbalance where the scales need to be, balanced to grant women justice. Hence, justice here is much more closely related to helping restore the power balance through the lens of equity and not focusing on equality, neutrality, or even individual rights like the modern state courts. Note, though, I don't want to glorify or romanticize Shalish. I don't want to ignore its patriarchal and other discriminatory practices. I don't want to define Shalish or claim that this is the general rule of thumb. Rather, I'm interested in taking a nuanced approach to study moments in Shalish where it actually works and then trying to understand why it's working. I'm more interested in alternate imaginations of law and evidentiary processes that resonate a bit more with people on the ground, which recognize things like women might not have access to their own kabinnama, women might be duped to sign fake papers thinking that they are signing kabinnamas, bribes to falsify information in kabinnamas are very common. For example, the qazis change the age of girls when they're underage, right? So that's not a fact. The then mahar or kabin money that the husband owes his wife when Muslim couples get married, that's often altered, probably after marriages. I've been to a couple of cases where that happened. So the authenticity of the kabinnama can be questioned. The other issue is this kind of prevalent practice of court marriages or affidavit BA, as it's called. So this is a local term for when couples go to a lawyer and get an affidavit stating that they're married or they intend to get married. And many times women, they push to get an affidavit or notarized paperwork from lawyers, thinking that this piece of paper proves marriage and this holds more weight in state law rather than getting a kabinnama, which they think is more Islamic and not related to the state at all. Now, all these common practices and assumptions on the ground complicate how marriage is conducted and in turn how to prove it. That's why analyzing the how and why Shalish use digital evidence the way that they do helps us recognize all these shortcomings of modern state law and its evidentiary process that aren't as obvious on the surface. Another example of how digital evidence helps bring out the gaps in modern state courts is when women use it to prove harm and violence. Now, women go to modern state courts wanting when women go to modern state courts wanting a divorce due to harm and violence. Not that it's very common, because a lot of times women would rather stay in a marriage with violence rather than get a divorce. But the few times that they do go to modern courts wanting a divorce due to harm and violence, they find that it's extremely difficult to prove. Women generally need medical certifications within a certain framework, paperwork filed with the police or relevant authorities, and sometimes rarely having witnesses testify, but those are not guaranteed to work as valid evidence. A lot of times it doesn't work. If you don't have any of these, it's close to impossible to prove violence. Many times women go to courts months after their bruises have healed, and then how do you prove violence in closed quarters then? During my fieldwork in Shalish, women often use digital evidence to prove violence. Women sometimes secretly recorded their husbands or in-laws beating them, and that worked. Harm to one's mental health, though, is harder to prove. But in one case in Shalish, a woman presented audio recordings of her phone conversation where her husband and mother-in-law were threatening her and saying derogatory comments, which helped her get her divorce. Now, Bangladesh's state law, which people assume as more progressive, don't necessarily have the space for these kinds of evidence. In fact, the current state law places women at a disadvantage when they present these kinds of evidence, since the first reason is photo, video, audio recordings are usually considered inadmissible, and digital evidence that are taken without the consent of the accused are usually in violation of privacy and transparency laws. So in the prevailing acts related to this, Section 26 of the Digital Security Act of 2018 says that the punishment of an individual taking photographs of another individual without their consent can include fines as well as imprisonment for 5 years. Section 53 of the same act states that this violation is a non-bailable offense. Section 63 of the Information and Communication Technology Act of 2006 states that the recording and leaking of personal telephone conversations is a breach of privacy and punishable by state law. So while these laws might be useful with regards to user data being protected from predatory institutions, there needs to be recognition of existing power structures and social contexts where women have very little means to generate evidence to prove cruelty and abuse, and the current DSA and ICT acts can be used to favor the perpetrator rather than the women who's being abused and treated with cruelty. To conclude, though, I want to state that studying Shalish helps understand several complexities, such as recognizing that there is certain evidence that state courts demand that women don't have access to, recognizing that the limited evidence women can provide are sometimes considered inadmissible in state courts, recognizing that state laws can further punish women for the evidence that they can provide, understanding how Shalish helps, problematize the superiority of current documentary evidence that are considered factual and authoritative, understanding that for rural women and many other marginalized communities, justice includes courts helping them mitigate social ostracization, and that compensation includes both monetary and symbolic reparation. Now, even though, this is a project on Bangladesh, it has much more broader stakes. I argue that studying non-state legal systems like Shalish provides a lens to recognize the shortcomings of the theory and praxis of the rule of law of the modern nation state. It provides a lens to understand alternate imaginations and epistemologies of law and justice, which generate an evidentiary process that can recognize marginalized community standpoints. It can recognize their positionalities, their social context, which lead to more equitable outcomes in certain types of cases. Now, I don't intend to generate a binary between state and non-state courts, because on the ground, they do interact and influence each other in complex ways. Rather, my goal is to problematize the certain sensibilities that promote ideologies of universality or rhetoric of superiority of modern state courts, and think of law using other frameworks that are prevalent in practice on the ground. Thank you so much for your time. I look forward to questions and comments later.
Thank you, Salva, for your presentation. I think that was really illuminating, and you basically highlighted a very important area of law that we definitely need to look at in Bangladesh, right? As we all know, that corporate accountability for road crashes in Bangladesh is a very important area that Takbir looks at, and that is something Takbir is going to present now. Takbir.
Right, thank you, Ishraq Bhai, and thanks to all those who have joined us this morning. I must warn at the outset that my presentation is certainly not going to be as illustrative or aesthetically pleasing as Salwa's, so I'm somewhat concerned, but I'll still try to make it as interesting as possible. So as we know, in August 2018, student-led protests broke out across the country, demanding with the common chants, we want justice, and also Nirapod Sorok Chai, i.e. we want safe roads. Now, there were a number of demands that the students were making, but at the heart of these protests and at the heart of their demands actually lies this call for corporate accountability of transport companies who have long operated in a manner that endangers human lives, particularly pedestrian and passenger lives. So at the heart of this protest then was this demand for accountability for these corporations who have long been unaccountable and have been able to profit at the expense of people. So in this paper, then I explore a very technical legal doctrine of vicarious liability as a form of corporate accountability, which has emerged somewhat and which I believe should emerge even further. So vicarious liability essentially would entail or require these transport companies whose buses kill people to compensate road crash victims, kill or injure. So that is the very so I'm looking at a general demand of the people, how it can be met through a very technical legal doctrine, which has emerged in Bangladeshi law and case law, but has remained somewhat underdeveloped. So it has room for further, growth. Now, I examined this development under 4 different liability regimes in law. So the first one is a colonial law that's called Fatal Accidents Act. And I look at it through the Bangladesh Beverage case, one of the earliest and most well-known tort cases in the country. The second liability regime is the Motor Vehicles Ordinance 1983, which is actually repealed now. And I look at it from the much discussed Catherine Massoud case. And the third liability regime I look at is the Road Transport Act 2018, which was enacted right after the student-led protest in 2018 and repealed the Motor Vehicles Ordinance. And finally, the fourth liability regime that I look at is the Article 102.1 of the Constitution, which allows citizens to apply for remedies if their fundamental rights have been violated. And I look at it through, again, another very high profile and much discussed case, which is of Raji. So to begin with, I just wanted to give an overview of what road crashes, like what the situation is with road crashes in Bangladesh. So firstly, according to the Bangladesh Jatri Kalyan Samiti or Passenger Welfare Association, there around 6,686 people died in 2020. Now, if you calculate the daily average, that means over 18 people died in the very year which had unprecedented restrictions on vehicular movement due to COVID-induced lockdowns. And still 18 people died on average, according to this very conservative estimate. Now, research has shown that road crashes in Bangladesh, 90% of them are caused by 2 main causes, which are overspeeding and careless driving, according to the Accident Research Institute in Buet. Now, experts have also suggested that what incentivizes these overspeeding and careless driving on part of these drivers, because they're not incapable of driving responsibly. It's just that their source of earning depends on the number of trips that they can complete. So the higher the number of trips, the higher the pay, because they receive a trip-based payment. So naturally, as you can see, this business model that has been imposed is actually incentivizing drivers to finish as many trips as possible in as little time as possible. Now, according to a research by PPRC from 2014, 85% of drivers in Dhaka said that they received the trip-based payment, while only 8% or 8% said that they received a regular monthly salary. Now, in August 2018, transport owners promised that they would replace the trip-based system with a monthly salary, because they acknowledge that this kind of payment incentivizes reckless driving, which then leads to the loss of life. But according to recent reports, suggest that this promise is yet to be fulfilled. The other practice that incentivizes or institutionalizes reckless driving is shoddy recruitment. So reports suggest that the vast majority of drivers do not even have a valid license. And finally, the third institutional practice which incentivizes reckless driving is the fact that owners fail to ensure that their vehicle has a fitness certificate in the first place. So according to a report submitted by BRTA, almost 5 lakh vehicles were, did not have fitness certificates in Bangladesh. So as you can see, these three institutional practices, when you combine the trip-based payment with shoddy recruitment and unfit vehicles, these intersect to create a sector where reckless driving becomes a norm and loss of human lives due to road crashes becomes the huge social cost that citizens are forced to bear, with those at the helm of such violations never having to pay the price. So that is why I believe vicarious liability is the form of corporate accountability we need in the transport sector to eradicate road crashes. Now, so I just wanted to say what is vicarious liability. Vicarious liability is so in a nutshell, it means where a company would be held liable for the wrong of their employee. So in our context, it's when a transport company will be held liable to pay compensation for the wrong of their bus driver, which, the bus drivers who are the ones recklessly driving. So they're the ones who are committing the wrong, but the companies would have to compensate. Now, there are 2 steps to this vicarious liability test. The first, there would have to be, the wrong has to be committed by the employee. Right, so the bus driver has to be the employee of the company being sued for compensation. Secondly, this wrong has to be committed in the course of their employment. So when the wrong was committed, it would have to be it would be in furtherance of their employment. It can't be outside their employment. You may ask, why can't we just hold these companies directly liable? Because they can be held directly liable as well, but vicarious liability is actually more strategic because it does not require the claimant to prove fault on part of the transport company, even if they may have fault. So there are both these options available, but I say that vicarious liability is the more strategic choice because you don't have to prove fault on part of the companies necessarily. You just have to show that there was a wrong committed by their employee and that this employee was employed by the transport company in question. But, my analysis of the case law suggests that courts don't often recognize the difference between vicarious liability and the direct liability of transport companies. And they often, their discussion is often overlapping both these forms of very distinct liabilities. Now, The utility of vicarious liability lies in the fact that it would incentivize risk management on part of these transport companies. So as scholars have argued, that imposing vicarious liability aims to create incentives for an enterprise to control risks and to spread costs to more efficient risk bearers. And this philosophy was also highlighted by the High Court division in the Bangladesh Beverage case, where they said that an accident can be said to be the materialization of risk, and liability can be allocated by replacing the question, whose fault was it that this accident occurred, by the question, whose risk was it that this accident might occur? Now, moving on to the first liability regime. So the Fatal Accidents Act was introduced in Britain and British colonies to give family members the right to sue if one of their relatives died as a result of a wrongful action, because previously they did not have the right to do so because the right died with the person. Now, so therefore, family members under this law have the a right to sue for wrongful death, a right to sue for compensation for wrongful death. And Section 4 clearly states that person includes corporate bodies as well. Now, the Bangladesh Beverage case related to the death of a famous journalist, Muzammal Hussain Muntu, who was crossing the road when a delivery van belonging to Bangladesh Beverage Industries was speeding from the wrong side of the road, ran him over and fled. He was rushed to the hospital, but he died. He was pronounced dead on arrival. And then his wife, Roshan Akhtar, did what was unheard of at that moment and sued this company for 35 million Dhaka and was awarded so by the district court in 2003. Now, the Bangladesh Beverage did what any corporation would do, which they appealed to the Supreme Court, the High Court division, and then the High Court division rejected their appeal because they tried to argue that this driver was not actually acting in the course of employment. But then the High Court pointed to the fact that they had earlier defended the driver and tried to blame Muntu as being the negligent party here. So the High Court rejected the appeal. But what the High Court did is they reduced the amount that was awarded for pain and suffering from 30 million to 15 million. So the total compensation amount was now 20 million. Then the Bangladesh Beverage appealed to the appellate division, the highest court of the land, again, but this was unsuccessful. But what they were successful in is getting the compensation amount reduced to now 17 million. And interestingly, the appellate division looked at Roshan Akhtar's earning as an associate professor herself as a basis to reduce the amount for pain and suffering. Now, this remains unclear to me why a spouse's separate earning source can be a basis of reducing compensation for pain and suffering. So that's quite odd, I felt. But the reality is Roshan Akhtar is yet to receive her compensation 30 years after filing her case and 5 years after the highest court of land affirmed her compensation award. Moving on to the second liability regime, this is the Motor Vehicles Ordinance actually introduced a very progressive corporate accountability framework because all motor vehicles owners were they were bound to have insure for third-party risk. And Section 111 introduced the no-fault vicarious liability of motor vehicle owners to compensate road crash victims. So this would cover death, injury, and property damage. And these would have to be filed before motor accidents claims tribunals. Now, we know the Catherine Masood case related to an unlicensed driver who was driving an unfit vehicle, which led to the death of Tariq Masood and Mishuk Munir and others. And what was also found is that that driver was also being paid per trip, and he did not have any brakes. So that is what caused him to overspeed. Now, unlike Bangladesh Beverage case where there was a clear owner or a transport corporation, here the bus was owned by someone, but it was being operated by another company, and it was leased to a bank, and it was mortgaged to a bank, and it was also insured with another insurance company. So Catherine and her legal team sued all these parties for 77 million BDT. So the formal bus owner in paper, the corporation that was controlling the bus, the driver, the bank, and the insurance company. So because of the Motor Vehicles Ordinance progressive corporate accountability framework, all these corporate parties were able to be sued for compensation. Now, in 2017, the Supreme Court awarded 43 million BDT to Catherine Masood, and it apportioned liability. So the bus driver had to pay 30 lakhs, the insurance company had to pay 80,000, and the bus owner and the bus controllers had to pay the remaining sum. So as you can see, due to the Motor Vehicles Ordinance progressive corporate accountability framework, all these parties who were involved in causing this tragic loss of life had a tangible form of liability that was imposed by the court. Now, this was in December 2017, right? So 7 months before countrywide student protests broke out, and an immense buzz was generated where corporations were finally waking up to the reality that they could be held liable for causing the loss of life. And then in July, students across the country demand the same thing, which is that corporate accountability. Now, in this context, what was happening is there was a draft Road Transport Act or Road Safety Law, which was, in the table as far back as 2001. And as a result, in an attempt to, appease student protesters, this was enacted in October 2018. Now, this act, it repealed the Motor Vehicles Ordinance, right? And it was very much presented as the answer to student protesters' demands. You wanted road safety, we're giving you road safety, and here's the law that will make it a reality. Now, the sad thing is when you inspect the compensation framework under this law, what it does is it replaces a road crash victim's right to sue for compensation in court with a very charitably titled right to apply for compensation from a financial assistance fund. Now, from the get-go, you can't, like, compensation and financial assistance are never the same. Compensation is a matter of right, financial assistance is a matter of charity. But what this act does is it conflates the two, and it blocks the path to corporate accountability that was present in the Motor Vehicles Ordinance. Now, this fund is governed by a board of trustees that is mostly comprised of government officials, and it has representation from associations of transport owners and workers associations, but it actually does not have representation from passengers or pedestrian welfare associations, which actually make, whose interests are being much at stake in road crashes, as we know. So there's a lack of representation there. It does not have a duty, it does not put a duty to motor vehicle owners to insure against third-party risk, as the Motor Vehicle Ordinance did. And most importantly, it removes the vicarious liability of transport companies to compensate for road crashes. So the only contribution, monetary contribution that motor vehicle owners have is to a very vaguely termed duty to compensate on a lump sum or annual basis to this fund. And failure to do so would lead to some sort of disciplinary action, such as cancellation of route permit and registration of their vehicle. But the fact remains that previously, under the Motor Vehicles Ordinance, they had a clear no-fault vicarious liability to compensate for road crashes, which they simply do not have under this law. So if the Catherine Masood case was filed under this act, there simply wouldn't be the same outcome. So someone like Catherine or anyone impacted by a road crash would just have to apply from a charitably titled financial assistance fund, and they wouldn't be able to take negligent corporations to court. So this was a huge blow to corporate accountability that had been made by the Motor Vehicles Ordinance and the Catherine Masood case. So I would say this act was the unmaking of corporate accountability for road crashes. Now, finally, I come to the final
liability. You need to wrap it up.
Yeah, minutes, so I'll take 3 more minutes. So the Constitution came to the rescue in a context where corporate accountability was blocked. So as we know, the Constitution guarantees a set of fundamental rights, and if these are breached, then citizens can apply for a remedy. And the Supreme Court has the power to order this remedy against any person or authority. Now, many of you will remember that Rajiv case pertained to a young man whose hand was maimed as a result of 2 speeding buses. Later on, he died. So one of these buses belonged to PRTC, the other belonged to a private company. And these buses, again, were racing to reach more passengers, and that's what caused Rajiv to die. Now, the private company tried to argue that the test for vicarious liability failed when they were sued by a public interest lawyer. They tried to say we should not compensate Rajiv's family because the person driving the bus wasn't even our employee. They were employed by someone we had leased the bus to. But what the Supreme Court did is it found that the bus was being run under their name and that the route permit was under their name. So they said it doesn't matter that you did not yourself hire that driver. You are essentially in control of the vehicle and you're in control of the driver that killed Rajiv. So you will have to compensate for his death. So here, as you can see, the classic test for vicarious liability was being modified to give a remedy to a victim of a road crash. Now, I'll just say that the key advantage to claims under Article 102.1 is that the victims do not have to actually prove fault because independent inquiry committees are formed and the court actually asks the state to pay members of this independent inquiry committee for their service. In the Rajiv case, compensation claim was 10 million, but it was awarded 5 million because the court said we must consider the socioeconomic position of the country, and also because Rajiv's brothers have the option to seek higher compensation in private law. But what's also interesting is that they said that Shahjan Pariban, the private company's liability extends to all their directors as well. So this is a sweeping corporate accountability that was imposed due to constitutional litigation. Now, in closing then, out of the 4 liability regimes that I looked at, so the Fatal Accidents Act was good as an initiation, but it's, as I said, it's limited to deaths. So it won't give remedies to victims who have not suffered death. And the Bangladesh Beverage case shows that despite compensation awards from the highest court of the land, one of the claimants is yet to be compensated. The Motor Vehicles Ordinance was actually a very progressive corporate accountability framework due to the no-fault vicarious liability and the mandatory duty to insure, but this has, as the Catherine Masood case showed, but as we know, this has been repealed by the Road Transport Act, where the corporate accountability was unmade and a charitably titled right to apply for financial assistance was instead introduced. And it has no duty to insure either. Now, within this unmaking of corporate accountability, constitutional litigation emerged as a form, a path through which corporate accountability could be established. And as the Rajiv case showed, that this was very much possible, and not only the company was liable, but also the directors who are involved in the company itself. Although the amount is much lower than the private law claims, but it shows that you have both the options. You can claim compensation in public law, but for a higher amount, you can go to private law. But I don't want to sound too optimistic. So the scope of compensation under Article 102.1 very much depends on the direction that public law compensation jurisprudence goes in the future. It is still an emerging area of law, and the judgments that have been pronounced so far is not actually very robust. It's very precarious. So the extent to which the constitutional right to life will be protected by public law compensation very much depends on where the Supreme Court takes this jurisprudence. So it is through that, unsettled area in the future that I end my presentation. Thank you.
Thank you, Takbir. That was a lovely presentation. And I think you touched on a very important area which the panelists would discuss. We're extremely lucky and privileged to have three eminent discussants amongst us who are basically very experts in their own fields. I would kindly request Dr. Manan Ahmed to be the first discussant. Professor Manan Ahmed is an associate professor in Columbia University. His areas of specialization include intellectual history in South and Southeast Asia, critical philosophy of history, colonial and anti-colonial thought. Professor Manan is interested in how modern and pre-modern historical narratives create understandings of places, communities, and intellectual genealogies for their readers. He's a member of Columbia's Committee on Global Thought, an executive editor for Journal of the History of Ideas, an associate editor at Comparative Studies of South Asia, Africa, and the Middle East, a member of the South Asia Council at Association for Asian Studies, and on the editorial board of Philosophical Encounters. His very important book, our first monograph, A Book of Conquest, Chachanama, and Muslim Origins in South Asia, was published by Harvard University Press in 2016, and talks about intellectual life of an early 13th century Persian history, Chachanama, also known as Fatanama-i Sindh, Book of the Conquest of Sindh. He also, his second monograph talks about the loss of Hindustan, the invention of India, also published by Harvard University Press, tells a history of the historians of the subcontinent from the 10th to the early 20th century. He is currently working on two book projects. One, under the contract with New Press, is on memory, history, and historiography in Pakistan. The second is on decolonization as a method of praxis for history writing. So I'll kindly request Dr. Manan Ahmed to discuss the two papers that have just been presented.
Thank you so much, Dr. Siddiqui. I want to thank BLAST and the organizers for this important conference, as well as Sarah Hussain and everyone else who's have been kind enough to allow me into this space as a discussant. As Dr. Siddiqui mentioned in his very generous introduction, I am a little far from the kind of expertise that is on display in these wonderfully written papers. I really learned a lot from both Salwa Haq's paper and from Takbir Huda's papers. And I'll try and kind of think through some of the questions that emerge into my own reading from these papers, and think about, I guess, in taking the kind of the question of rights more generally, how we might conceptualize the moments of transitions that are in both papers. So let me begin with Salwa Haq's paper, which, as you heard, and I was lucky enough to read the paper, the kind of written paper, as well as the presentation. But as the audience heard, this paper kind of thinks with two of the, let's just call them institutions, the state courts, as well as the Shalish, and thinks about various modes in which they are represented in literature and popular understanding, courts being understood as secular, Shalish maybe in some cases wrongly as traditional or Islamic, both having various kinds of jurisprudence, whether it's of the case law or it's of Islamic jurisprudence. And both having a type of claim towards consensus building, but with very marked differences in scale. And so what we have here in one case, in the case of the state court system, especially concentrating on the processes that Haq is interested in, which would be customary law, generally speaking, or family law, family court, divorces and marriages, domestic abuse, instances perhaps also of violence, gender-based violence. And what the paper beautifully demonstrates is that the claims of what is admissible as evidence in order to reach a consensus, whether in the legal sense or in the sense of a community understanding of a transgression having happened or a form of social relationship that is broken or constituted. So what are the claims of this evidence? How do we create a baseline for understanding there? And for the case of state, as Haq demonstrates, digital evidence is inadmissible because of the medium itself. And in the by the Shalistars or in the Shalish system, you have the capacity of women who may not have access to the legal documents, or maybe at a disadvantage when it comes to forms of emancipatory or recuperative measures, can use WhatsApp messages or text messages or videos or other forms of digitized means of documentation to have themselves heard. Now, that's the first thing that I would ask Hawk to kind of think through, which is that the gendered question of evidence making remains a priority in both cases, right? The question that a woman's voice, the type of evidence that she can bring forward remains, let's just call it, unstable. Now, in the case that Hawk describes for us, in some of the cases, obviously, any field-based, ethnographic-based work would have to wrestle with the question of scale. But in the cases that Hawk is able to give us a vision of, what we see is that the Shalish court is interested in creating and maintaining a type of civic harmony, a type of consensus in a community, which allows them in some cases to listen to the woman's perspective, to have her give document that this was a legal, and to the best of her knowledge, marriage, and hence she, deserves whatever recompense or whatever recognition that she needs. Or in the one case of a domestic abuse situation, that she should be given relief. And in the case that we can just as easily imagine, perhaps, where the community peer or the community social consensus is directed against the woman. Perhaps there's a idea in the neighborhood that a woman is, quote unquote, of loose character or moral prior to the case being brought. So the digital evidence that is accepted in at least the cases that Hawk talks about is predicated on a type of relationship with the community that is unstable, because the woman, in constant danger, if not reality, of being deemed prostitute or deviant, etc., her voice, her testimony cannot simply be admissible in any sense, either in the state or in this Shalish court, without this instability that surrounds her. And that leads us to kind of think, I think, about the question of rights in this particular sense, that is predicated not necessarily on the medium of evidence, but the role of the individual, in this case, the women who are petitioners, in a patriarchal normative structure. Now, how does the Shalish court, which, as the Hawk demonstrates, are largely men? There's an example that she cites of at least a few NGO-based Shalish courts that have women majority. How would we think of that, a group of peers as women, and also how would we think of that as a contingent case for recognition of the innate human rights, gendered female? So I guess my set of questions for Shalish versus state was, in one sense, I see this as a type of, as you're very careful to point out, these are overlapping categories. So this is not a dialectic. This is not, an evidence with each other. But I also think there is the state is interested in something necessarily legal because it is a legal state of affairs that it wants to document. That is the Nikanama, or etc., are a type of legal fictions, right? So you don't discuss facts in this sense, but there's a concept called legal fiction, which is just about as real or unreal as anything else. And in this legal fiction versus this community consensus that the Shalish is able to ask, I see a precarity of rights language in both of these. So that's something that combines them is not necessarily the ways in which they control or think about evidence, but the ways in which in a society, a person's self and body are protected with their own innate ideas of wholeness. And what is the kind of domain of politic and the political in which the self can be articulated without the mediation of a court of elders or a civil court or a legal court. In other words, I would ask you to think a little bit more about the type of self that the petitioners in the Shalish court put forward. There was wonderful evocative language in the ways in which you describe, do you not see me now? Or what do you want to make of me? Which I think can be really kind of thought through a little bit more to give a little texture to the subjectivity that you are kind of putting forward. So I'll stop here, and then I want to come back to your paper in the end. But I want to turn to Takbir Huda's paper, which again, both of these are incredibly well written pieces. But for a law paper, which I have read a bunch of law papers because I have some friends. It's beautifully written, so congratulations on that. Takbir, one of the things, this is, you're talking about an unsettled law. You've given us a wonderful history of how there are 3 or 4 ways in which corporate accountability kind of intersects with the settled and unsettled nature of harm to the citizen, harm to the public, that enables a call for redress. So just reading it, I can see that what you've done is incredibly careful work, and it's something that I will leave to the lawyers to figure out. But I do want to ask you to think through a couple of things that a non-lawyer like me was riveted with in your conversation. And it ties with, I feel strongly with Huck's paper as well. And that's the role of the kind of public. And again, this goes back to the idea of consensus, right? So you begin with these student protests, and you talk about how there is a demand, a public demand for safe roads. There's a public demand for protection of one's body, one's integrity of one's body in movement from home to work or home to school. And even in this corporatized economy where the necessity for, as you say, rides-based compensation forces a broken infrastructure to be filled with speeding drivers who are drunk and or too tired to figure out what's happening. Even there, the public, in its demonstration, in its call for redress against an 18 deaths a day, horrifying, demands answers from the state, demands that something be done. Now, what you show is that there are 3 or 4 ways in which various types of responses have been made, but and more or less they have stripped rights away rather than grant rights, especially in the case that you show with regards to the commission that's set up, in which one has to apply for almost in terms of a social welfare fund rather than a just compensation for a loss of a loved one. How leaving the kind of constitutional unsettledness of the law aside, what happens with it? How would we kind of think about the protests and the public demand for safety and recompense help us think about the framework within which a body, a working body, a traveling body, a commuting body, a student body, a body in public is seen. How do we kind of change that idea that a human being who is harmed and or killed in a public sphere by corporate malfeasance or by the malfeasance of those who are responsible for integrity and well-functioning of our physical infrastructure, that they be held responsible and pay for either the individual's loss or the loss to the greater society. In other words, how do we kind of think of the idea of public commons and public responsibilities more broadly? Now, the case of the question of the Constitution and the question of court, which grips not just Bangladesh but India and Pakistan in a vice where these are the places we turn to for solutions, in as far as they are the instruments for taking our liberties away. At least that's the kind of long history of them. How do that idea of the legal framework, the constitutional framework, limit the ways in which we can understand this understand this protest? Are the spaces for us to think about a collective necessarily only going to end up in the arms of the state as jurist or the state as provider? And I think this is the place where I feel there is a important overlaps between these two papers, which is that the public that is imagined in the Salish court, or the public that's imagined when a protest breaks out after the death of someone in a street accident, and we call for some idea of safe roads, or we call for some notion that a man respect the vows that they have taken to a woman. That idea of the public, that idea of a community is under-theorized. And I don't mean that in your papers, I mean that in our own kind of theoretical engagements with the communities as large. We tend to think of religion as a place from which to theorize such things. And so we think about, how do we make deen or faith a type of understanding for this? Or we have to kind of think of international languages, like languages of human rights, etc. In both cases, as your papers show, there are other forms of thinking and belonging that remain at the margins of what we're trying to think about, which is integral, I think, to a type of self that is visible at these crisis points, when someone wants justice, when someone is looking for recompense, when someone is looking for emancipation. The language that is used, the place where appeal has to be made, and the authority that one endows with, that someone is endowed with in order to fulfill that claim for the call for justice. Can the state alone bear that burden? Can any idea of corporate entity be responsible in that sense in the late capitalist stage that we're in? And I don't have answers, but I do think there are important ways in which both of your papers help us towards that, towards informal and formal ways in which including the papers themselves, so including your own scholarship, including the work that you're doing yourself, I think help us think about some of these ways. And I wonder the lessons that one can take from your papers then for thinking about India, thinking about Pakistan, thinking about the type of travails that we have as a collective across the subcontinent. So I'll stop there. I want to thank you both for really illuminating papers, and I look forward to the other comments. Thank you.
Thank you, Professor Ahmed. I think those are very useful comments, and I hope the presenters would take your comments on board while writing their paper and extending those issues as well. Thanks again. Now, I would kindly request Professor Aziz Zerhak, our second discussant, to give his comments. Professor Hawk is a scholar of US and comparative constitutional law. He works on topics ranging from democratic backsliding to regulating AI. He regularly writes for Washington Post, the New York Times, and many other non-specialist publications. Before joining the law school faculty, Professor Hawk worked as counsel and then director of the Brennan Center's Liberty and National Security Project, litigating cases in both the US Court of Appeals and the Supreme Court. As a senior consultant analyst for the International Crisis Group, he researched and wrote on constitutional design and implementation in Pakistan, Nepal, Afghanistan, and Sri Lanka. He was a law clerk for Judge Robert D. Sack of the US Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg of the Supreme Court of the United States. He's also a 2001 graduate of Columbia Law School and was also awarded the John Otternew Prize for the student graduating first in their class. Now I'd kindly request Professor Hawk for his comments on the two papers presented and his feedback in general. Professor Hawk.
So thank you very much for those introductory comments, and thanks very much to Salwa in particular for inviting me to this conference. I really appreciate the opportunity to read both of these papers and to have a chance to engage with them. They're both terrific, careful, and engaging pieces of legal scholarship, and it's been a delight to think about them. I should begin, though, with a disclaimer. I'm trained in the United States. I practiced law in the United States for 7 years, and I've taught mostly constitutional law in the United States for another 12 years. I have no experience with and have never developed expertise on Bangladeshi law. It's true that I've worked in other South Asian countries, but the issues that I worked on there are not related to the ones pertaining to tort law, family law, or legal anthropology that are at stake here. All of which is to say that the comments that I'm about to make stand upon very modest epistemic foundations, and I'm acutely aware of the limits to what I can contribute to your detailed accounts of events, legal rules, and legal developments that are beyond my normal remit as a lawyer and then as a scholar. And what I'm going to try and do is to identify a number of descriptive, empirical issues that I think warrant clarification, focusing in particular upon the papers that were kindly shared with me. And then to flag a number of normative questions that pertain largely to the gestures toward reform that Salwa and Takbir make at the end of their analyses, gestures that I think might be usefully problematized and questioned. Okay. So let me start with Salwa's paper because she presented first, and then move on to Takbir's. But I'll try and identify a couple of points of commonality with respect to the papers as I move through them. So Salwa's terrific ethnographic study of Shalish tribunals makes a series of entangled descriptive and normative contributions. To my mind, the central descriptive contribution is its thick and compelling accounts of the manner in which Salish resolved disputes, such as the one that she described between Pakti and Shujun. From that description, however, flows a normative critique that hinges upon the rigidity of evidentiary rules in state courts in relation to their exclusion of digital evidence, and also their problematic reliance upon the paper Kamidnama as proof of marriage. Let me flag a question that arose with respect to the descriptive element of the paper. And this is I'm going to phrase this in terms of a note of surprise. Despite an initial precautionary note that Salwa offers in the paper. And it's a precautionary note that she echoed in her oral comments a few minutes ago. The paper offers a fairly dichotomous portrayal that contrasts the benevolent institution of the Shalish with the corrupt or incompetent institution of the state court. As Salwa carefully notes, though, Shalish interventions are designed to help, and I quote here, reinsert women back into their community while mitigating social stigma. It seems to follow from the analysis in the paper that the absence of evidence of malign conduct by Shalishes in relation to women and the concatenation of evidence of hostile conduct or misogynistic conduct by state actors in like cases suggests that there is a clear and fairly distinct binary as between the two. As Salwa said in her comments, this seems implausible. It seems particularly implausible in light, actually, of the account of judicial action that Takbir gives, where Takbir identifies a number of instances in which courts exercise what looks to an Anglo-American lawyer like a form of equitable discretion and recognition of facts beyond the record, which are at odds with the account that Salwa gives. I'd note also that the dichotomous treatment of institutions here, and by dichotomous I mean normatively heterogeneous rather than functionally distinct as opposed to entangled. I think those are two separate dichotomies which should not be confused. The dichotomous normative treatment of institutions here has an odd implication for the way in which we conceptualize female agency in the context that Salwa describes. So in the midst of her paper on page 19 of the draft that I have, Salwa offers a block quotation from one of her respondents. And in this block quotation, the woman in question signals her both capacity and an attempt to opt between different institutions as a way of seeking advantage or protection where it was available. A strictly dichotomous account of the Shalish as opposed to the state tribunal denies the possibility of that kind of agency to women. It suggests that a woman who fails to leverage the Shalish forum acts in a self-defeating fashion. So I think even within the evidence that Salwa marshals within the bounds of the paper, there's reasons to think that her dichotomous presentation of Shalish versus state courts elides important qualities of female agency that merit exploration. Let me turn now to the normative. Salwa's analysis has normative implications, and in particular, the proposal to reform Bangladeshi evidence law by drawing upon present UK law to expand state courts' consideration of digital evidence strikes a clearly prescriptive note. Now, as a threshold matter, this proposal diverges from the central normative dichotomy of the paper to that point. That central dichotomy is institutional. It's not solely in terms of the evidentiary rules employed by the two forums, right? We move from the institutional to the evidentiary. I think that there's good reason to make this move, although I think it would be worth fleshing out. There is no particular reason to believe that state tribunals are incapable of incorporating and leveraging the form of ambient community knowledge and ambient moral judgment with respect to either personal or other matters that Salwa ascribes to the Shalish. Indeed, the jury, a body of persons from, as the US Constitution says, the vicinity of a crime, were valued precisely because they embodied the kind of community, moral, and epistemic vantage that Salwa describes as now embodied in a Shalish. We may have lost sight of that in both the United States and the United Kingdom because of the evolving and deepening institutionalization of courts. But it's worth remembering that the jury is an institutionalized form of the communal judgment integrated into the body of a formal state system. There's no functional or other contradiction between those two forms. So once we reject that, or once we move past that dichotomy, and once we focus upon the issue of evidentiary rules, I think that Salwa's right to question whether the evidentiary limitations upon digital sources in state courts and their complementary reliance upon paper Kabinnamas is a sensible one. Now, one way of thinking about this problem is in terms of a distinction that, at least in the United States, is taught to first-year law students. This is the distinction between a standard and a rule. A rule is a legal norm that is crisp, hard-edged, and clear in advance. By contrast, a standard is a legal norm that is woolly and that requires specification in the context of application. So, for example, accept only paper Kabinnamas is a rule. Accept all reasonable evidence of marriage is a standard. One way of understanding Salwa's proposal is that she wants a standard rather than a rule. I'm not convinced she's made a case for this. Rules have many advantages. Something like the rule that Salwa implicitly criticizes is used in American property and contract cases to deny recognition to certain transactions that are not memorialized on paper. The reasons for this principle, which is called the statute of frauds, apply squarely here. The statute of frauds enables parties before the fact, ex ante, to engage in planning free of particular kinds of uncertainty. Moreover, as its name suggests, the statute of frauds minimizes certain kinds of strategic behavior. It's thought that the forms of strategic and manipulative behavior that the statute of frauds particularly guards against are those engaged by legally sophisticated, more economically powerful actors. So if one thinks about the way that the statute of fraud is employed in contract and property law, one sees, I think, that the same sets of considerations, the same concerns about planning and the same concerns about extinguishing opportunities for fraud and manipulation apply in this context too. Perhaps a way of redeeming or bolstering Salwa's conclusion, the push towards standards as opposed to rules, is by pointing to the asymmetrical access that women have to different kinds of evidence. Right? Women may have access to digital evidence, but they don't have access to paper. Set aside the question of how that could be substantiated, query whether it's necessarily the case. Right? In the United States, actually for 200 odd years, the real property system has been organized around registries, land registries. There's the land registry serves exactly the same function as the statute of frauds. It's quite possible to think about reform in terms of centralization and documentation as much as it is in terms of moving from rules to standards. And I don't know which one of those approaches is right. I just, the issue that I would, or the question that I would rather turn to Salwa is how we know which line of reform is more likely to improve the lives of women in the context that she's describing. Let me turn now to Takbir's really terrific comparative analysis of several regimes for vicarious corporate liability and tort for traffic accidents. The virtue of this paper is that it really crisply and clearly maps out a sequence of evolving and somewhat overlapping legal regimes, and quite persuasively shows that the absence of effectual mechanisms of tort justice across several permutations of the law persists, albeit in different doctrinal or statutory forms. Nevertheless, it raises a number of descriptive and normative questions. Let me flag. And maybe that was an interruption telling me to hurry up. Let me try and flag as quickly as I can the descriptive and normative questions. So, with respect to the empirical claim or the descriptive claim in the paper, one of the central claims, one of the central historical moments that the paper describes is what it calls the huge blow to corporate liability inflicted by the 2018 RTA. I found the claim puzzling in the context of the paper for two distinct reasons. On the one hand, as Takbir nicely demonstrates, there was a paucity of cases under prior statutory dispensations. This poverty of litigation suggests that the substantive law governing liability may not be causally determinate of the number of cases being filed. Instead, one might infer from Takbir's account that it is the cost and the duration of ordinary legal process, the capacity for multiple appeals and jurisdictional shifts that operates as the more consequential rationing mechanism when it comes to access to damages. If that is in whole or in part correct, it's not clear at all why attention should focus upon the shifting substance of vicarious liability. A related puzzle is why, given the popular mobilization that's described as occurring in 2018, the RTA was enacted in the form that he articulates, describes. Was everyone fooled? Was this an instance of mass delusion with respect to the actual content of the law? I think it would be helpful here to just explain a little bit more of the political economy and circumstances of the measure's passage into force. So the normative questions that I'd want to pose Takbir are in a similar register to the ones that I framed for Salwa. To begin with, whereas I have a clear sense of Salwa's normative agenda, I am uncertain of the normative framing that Takbir intends to apply. So I think that there are two standard normative orientations in discussions of tort law in the vein that he is interested: corrective justice and deterrence. Deterrence might be another word for efficiency or social welfare. Corrective justice aims to make injured individuals whole and is formally indifferent to the frequency of injuries. Deterrence or efficiency aims to minimize or optimize the rate of accidents, right? It is indifferent to whether a particular victim is made whole. These are two analytically distinct normative aspirations. One can pursue corrective justice and be blind to deterrent. One can pursue efficiency and care not a jot for corrective justice. And they do not flow together. Often, it is true, compensation has a deterrent effect, but this is not always the case. Indeed, Takbir's account of the Catherine Massoud case demonstrates the way that discounting over time, or the discounting effect of time on a recovery, means that a defendant firm may well be indifferent to an eventual damages award, but simply because of the length of time that it takes. Or consider the idea of compensation for a government fund, as under the RTA. This advances the goal of corrective justice. It makes individual victims whole, or at least partly whole. It does not a whit for deterrence. So my view, and it really is just my view, is that focusing upon lowering the number and the cost of accidents is preferable to a corrective justice focus. I'm not going to defend that view here, but I will state it for the purpose of my following comments and urge Takbir to clarify what his normative compass is in evaluating this sequence of statutory regimes. So with the fact that I am a consequentialist in mind, let me offer two further closing thoughts for Takbir. So first, the paper focuses upon vicarious liability on the assumption that corporate actors have the best lever of control over their agents, as well as the deeper pockets. Query whether that assumption remains or will remain the case. At least in the United States, it's my impression that technology is already pulling apart that presupposition of a tight relationship of control between a firm and employers, at least in the transportation sector. Of course, what I have in mind here is the diffusion of ride-sharing apps that decouple owners, corporate owners of platforms, from their drivers who are treated as independent contractors. Consider whether that is happening in the Bangladeshi transportation economy. I don't know whether it is. But perhaps more importantly, consider whether proposals to increase the level or the intensity of vicarious liability would have the effect of stimulating that kind of legal change as a way of insulating firms from the prospect of that liability. Final point. If Takbir's ambition is deterrence, then I wonder why he does not say more about the role of insurance. In the United States, insurance companies play an outsized role in both public and private corporate settings in ensuring compliance with standards of tort liability, such as negligence and even strict liability with respect to exceedingly dangerous activities. Insurance companies are able to intercede in dangerous activities before rather than after the fact, and are able to pressure using the stick of increased premiums. They're able to pressure their clients into adopting measures that reduce the toll of third-party externalities, at least those captured by the legal system, that the activity generates. Here, the obvious reason for not relying upon an insurance mechanism is that the quality of the court system is sufficiently low that it cannot be trusted to expeditiously and accurately resolve factual disputes. Therefore, insurance companies don't have an incentive for enforcing norms or enforcing precautions on covered companies. But consider the possibility of the following legal regime. Companies might be held to be vicariously liable in strict liability for the accidents of their drivers. That is, a plaintiff could recover from a firm that employed a driver based upon a showing of factual causation, but not fault. Further, companies would be mandated by law to have insurance coverage to supply compensation adequate to cover the ensuing injuries. The dynamic of this such a scheme would be, the result of such a scheme would be to pressure companies through the lever of premiums to moderate risky behavior without imposing an inordinate burden on the courts. So thank you very much again, both to Takbir and to Salwa for a pair of terrific papers, and I look forward to hearing more from them.
Thank you, Professor Haq. I think those are very important comments that you have just made, and I hope Takbir and Salwa will take those comments and feedback on board while rewriting some parts of their paper again. And in that vein, I would now like to request Dr. Dina Haq. Professor Haq is a clinical associate professor at NYU. Her research is grounded in the study of Bangladesh, joins development studies, transnational feminist theory, and anthropology of Islam and human rights. She has published extensively on the global garment industry, non-state gender justice systems, and the cultural politics of Islam and nationalism in Bangladesh. She is currently engaged in a project on economic development, discourses of empowerment, and the travels of civilizational feminisms. Professor Siddiqui is a member of New York University Society of Fellows, on the advisory board of Dialectical Anthropology, and on the editorial board of Routledge's Women in Asia publication series. She's on the executive committee of the American Institute of Bangladesh Studies, AIBS, and an advisory council member of the South Asian Feminist Network, Sangha. Now, can you request Professor Siddiqui to give her feedback and comments on the two papers that have been presented?
Thank you so much. First, I'm very pleased to be back at BLAST, even though it's virtually, and especially in this gathering. Thank you to Ishraq and Salwa for organizing, and Salwa for inviting me, and to Sarah. Since this is a 50th anniversary retrospective of the country, I do want to say, before I launch into my comments, that I have tremendous respect for BLAST, which has become, I think, a national institution of sorts, whether or not it wanted to be. And I think that's quite a feat. So congratulations, Sarah, and to those who came before you and have built before you, and to those who labor behind the scenes every day. Having seen BLAST from the inside, what strikes me always is the range of work it does, from the public interest litigation to the academic research it does to further its advocacy, to rushing off to labor courts to deal with garment workers. So I thought this was a good time to say this. My comments are much more informal and briefer than our previous two speakers. I do want to say I'm very pleased to have this opportunity to engage with these two young, promising scholars, both of whom I know well enough, quite well. And their papers are provocative and exciting in very different ways. And their approaches to the law and to questions of justice have some interesting connections and overlaps, but also I think are a little bit different, partly because the subject matters are so different. So I want to begin with Salwa, particularly because, or simply because I'm much more familiar with and have written extensively on the Shalish and have looked at blast files, whatever. First of all, congratulations, you've got some fascinating new ethnographic material that I think we haven't seen before. It's really rich material. It's given us a window into how young women, young rural women, use technology, certain kinds of technology as a resource, because the general scholarship is very much more about how technology disciplines women, at least certainly in Europe and America, that's what the anthropology scholarship is about. So actually thinking about or learning about how women are actually, or these young women that you seem to have seen, are quite tech savvy in ways that I wouldn't not know, not that I'm a measure, but it is interesting to think of how they're managing, if they really are managing to, you know, take these little bits of film or video or tape words, you know, that their husbands have said. I think if we think about it, that has the potential to change a lot of things, from the teen talak, ke bollo na bollo, keu teen talak bollo na naki, to many other things. So who knows? I mean, I don't know, but I'm fascinated by what you've brought up and the possibilities that open up, perhaps, for women. And who knows that, you know, who knew WhatsApp and cell phones would open up so much, perhaps. And I'm going to put a perhaps on everything. But just the opening, just the possibilities to me seem really, really important to hold on to. That's that promise of another kind of resource, right? That's not just about the law or culture or religion. I want to flag three things that your paper raises, and they may seem obvious, they may not. I think having worked around in Bangladesh, having seen how most NGOs operate in Bangladesh, they're important. So the first thing you say, I think, when it comes to evidence, specifically digital evidence, the humble village Shalish tends to be more accommodating and flexible, and therefore potentially more in women's interests in terms of ruling, rather than the more so-called progressive national level formal state courts. That shouldn't come as a surprise, really, just because of the interpretive flexibility, the structural flexibility of something like the Shalish, which is actually quite different from a village panchayat, which is much more in India, which is much more institutionalized. Right? It's a much more fluid formation that we're talking about. But it does, for many people, it still comes as a surprise. And as you say, institutions like the UNDP and Human Rights Watch still have this sense of this backwardness, right? The third world backwardness that is seen and constantly being reproduced in institutions of tradition and culture. And I think your paper really pushes back against that basic grid of tradition versus modernity through which we are conditioned to, that structures our understanding of the law and what is good for women. And I see that again, you know, these assumptions are built into standard legal advocacy work that I know, and these, you know, this main opposition of tradition modernity maps into several other oppositions, of which, you know, we have religion and secularism, culture versus rights, but you know, custom versus law. But I think the state versus community, as though they were separate spheres, that's one thing that unpacked through your paper. Right? Or that there's a hierarchy. It's not just a duality, it's a hierarchy in so much of development discourse that feeds into how most NGOs think the way they do, right? And I think you're calling on us, inviting us, or whoever is going to read this, policymakers, to go beyond the binaries. It's not a question of one thing is better than another thing. Your fieldwork invites us to interrogate these assumptions underlying dualities, particularly supposedly in a Muslim context, right? And I won't go too much into that. I think people will know, but one thing that I think you could foreground is how these binaries obscure actual operations of power. And I want to go back to that, particularly in relation to class relations, which I think your paper doesn't. It's the one thing where I don't get a sense of who is at the shalish, what the class relations are from everything I've ever studied. It's mostly the poor women who end up at the shalish. It's mostly the more powerful men who end up rejecting, denying these so-called marriages, love marriages, affairs, whatever. So that kind of dynamic gets a little bit lost in what could be, in, I think, a little bit of romanticism about what the shalish does that I think other people were talking about. I think the shalish too needs to be historicized and contextualized. After all, I think much of the early material on the shalish is about how it is a very class and gender. It was an institution that reproduces class and gender norms, right? I think one of the things I'll never forget, and my research associate here is in the audience somewhere, is that he brought back to me was when we were doing research on Aino Shalish Kendro's Shalish, NGO Shalishes, this man said, Shalish Asharage, and before a lot of other changes, this man said, once our word was the law, Amra Jeta Boltam Shetai Ain Chilo. Ekhon to there are these multiple forms of Ain. It's interesting to think about what changes and what doesn't change historically. Anyway, so there's the binary, and clearly, I think what you demonstrate both is the interpretive flexibility of the shalish, but also perhaps the centralizing effect of both of codification and states. And there's a huge literature on this. Everybody from Judith Tucker talking about Ottoman Syria to other people talk about this, but it's worth keeping in mind. So you do all this interesting stuff, and I think you kind of, the conceptual issue you bring forward is that there is no a priori, there shouldn't be an a priori assumption of what will be better for women. And in fact, women themselves, at least in my experience, the shalish is one place they will go to, and if they can't find succor, they will go to the court or courted bhoy dekhiye. They will be, they'll leverage the fear of a court case to get people to do what they do, right? But it's not a binary, and I think you show that really well. I want to raise two issues that may not seem directly related to your argument, which I am totally, I'm very persuaded by, I am certainly, on scale and logic, excuse me. The first is on the form of the shalish and the content of the shalish. So the shalish is an institution which by convention functions on the authority and standing of shalishstars. It's their reputation, right? It's their ability that determines, it's saying it's they who determine what counts as evidence, what should be counted as evidence. So I think the question is not just about paper documentation versus mobile phone technology. And I can see what you're saying about what the spaces that open up with mobile phone technology. But I think, as you know, and you say on page 19 in relation to something Brinkley Messick says, you know that documents never stand alone. There's always a stamp of authority behind them. They're kind of meaningless if there's no, if you don't think about the power. And I was thinking as I was reading your paper about Nur Jahan of Potikchuri, whose father had a different kind of document, maybe it wasn't illegal, but who had the Nikanama, but who was still, who was still condemned by the Shalish, who was, the Shalish ruling was that she had committed zina. So it wasn't the document that was the problem at all. It was who was making the decisions and the power relations therein that was something to look at. And so therefore, it is true that Shalishthars are not bound by the Evidence Act, but I think there are other things. And I think here my is about local. I will say one thing I think from your paper that I really thought that made me think is that what Shalishthars have going for them is that they're not beholden to a legal liberal assumption of equality, that everybody's equal, that in a court, there's, which invisibilizes structural inequalities, right? Everybody from Kimberly Crenshaw will tell you that, but Shalishthars, in a sense, recognize the unequal positionality, and these are your words, and the structural asymmetry that women must navigate, right? And I think this is not necessarily particularly Islamic. It's local logic. I don't think we need to call it. It's perhaps, I suppose, for want of a better word, I would call it a non-liberal concept, where the world is understood as actually in practice hierarchical, and Shalishthars are going with that. But my second point is really about locality and scale. Shalish rulings are local judgments, and they tend to reflect local cultural logic embedded through power relations. So again, whether something will be determined to be testimony or not, truth or not, depends on so many other factors as well. And you brought this up, and I want you to think about this more, about how, I spoke to how everybody knows that certificates can be faked. I have actually spoken to public prosecutors, perhaps I shouldn't even say that, who will often, if they feel that the young woman in question, she will be made outcast, that if she's pregnant and she has a child out of wedlock, as they say, I have known them to procure for the girl's better, in the girl's interest, procure a false marriage certificate so the child won't be illegitimate. It's a very interesting, complicated thing, right? That goes beyond what counts as evidence. And, what do you do with that? So what do you do with that? I think where we end up in Bangladesh and so many other places is people want to talk about rights, but when it comes to questions of sexuality, sexual agency, there's a whole lot of other stuff there. Nobody really wants to deal with that, right? And you end up reinscribing in the name of, and I think this is true, it is more protective, but you end up reinforcing this system in which sex, marriage, heteronormative marriage, everything has its place. And that's something somebody like you can think of. I'm going to stop there. Takbir, I've probably spoken for way too long. Takbir, I'm on much less. I really enjoyed your paper. I learned so much I did not know, including this amazing phrase, vicarious. I kept thinking vicarious pleasure. I'm sorry. I don't know where these Victorian phrases come from. But this thing about vicarious or liability, thank you. I really began to think about it. I'm on much less certain ground with your paper. I'm really glad the previous speaker spent a lot more time on it. I have a couple of things that really struck me in relation to questions of accountability and this vicarious liability. One is that it really reminded me of something I'm really struggling with right now about the supply chain and garments in the garment industry, and how far up does liability go? When do you make, where is the responsibility? How do you stop, right? These are debates going around labor rights right now. That's one thing. The second thing is, I didn't know, living and growing up in Dhaka, these buses are a real danger, right? I had no idea. I really appreciated how you brought up that it's not working conditions so much, but the pressure to produce a certain amount of profit that ends up leading to these terrible accidents. So it is working conditions. And it's very similar to factories where the pressure to produce within time-bound production also leads to all kinds of accidents. So I saw some very interesting similarities there. Piece rate versus monthly rates. I kept reading and I kept thinking how, there is a larger capitalist logic there you might want to think about. I actually have one question, which is about the language of corporate accountability. You showed this amazing picture in your first slide of these young boys who were mimicking, in a sense, Noor Hussein's, original anti-Ershad thing on their bodies. They were protesting with their bodies. And I can't imagine that the only thing they wanted was corporate accountability. To me, that's a very impoverished phrase. And I say this as a non-lawyer. There is a lot more they demanded from the state. And here is where the difference, I think, comes in with Salwa too. I think that the claims making, the making of claims was in the name of the nation and in the name of citizenship. It wasn't some narrow corporate claims making. I think it's so much more than that. Whereas I think the women in Salwa's cases have a very different relationship of making claims on the community. Shalish is making claims on the community. It's not making claims to the nation state. That's a big difference. But there is, to me, again, there was an elephant in the room. I went and did a little bit of research because I don't know very much, but I know that the transport unions are the ones who seem to apparently control. They have a whole mafia around how buses run, when buses run, whether buses can be, which buses are can be taken to bus drivers can be taken to court. What do you do with those extra legal measures? I think it's wonderful that Blas won this case, Catherine Masood's case. It's so great. It's a great precedent. But what does this individual victory do? It's a precedent, but what does it do to change that larger structure? Or can it not be? I mean, so where does the law come in here? I think perhaps the one thing I found about the two papers is that in very different ways, they show how the law does not operate in a vacuum, and that the law is well, first of all, we need to think about what we call the law, but if we're talking about state law, then the law needs to have this kind of legal analysis is one node in a larger assemblage of power or something. And I'll leave it at that. Thanks.
Thank you, Professor Siddiqui, for your comments. I think both Salwa and Takbir, they're going to take it on board. Now I'm going to move to the question and answer session. And the first question is for Salwa. And this question is from Hassan Ashraf. And he says, in the context of legal pluralism in Bangladesh, whether you are looking at fatwas too. So basically, whether you're taking into consideration the fatwas as well. Salwa,
Yeah.
can you respond to that?
Yeah. Thank you. First of all, thank you so much to all the discussants for all their points. I just have to say that because I've learned a lot just from you talking about and what your takes on it were. So I really, really appreciate that. And we'll definitely incorporate a lot of that and think about a lot of the points that were made. To answer the question, no, fatwas is actually something that I'm not looking at, but I think like lots of women before me, their research working on fatwa has actually paved the way for me to think like this. So like lawyers like Sarah Hossain have worked on it, scholars like Dina Siddiqui, they've worked on it. And so it's there kind of in the same vein of kind of thinking about the problems of fatwa, complicating what that is it religious, is it not religious, what about it is problematic. In the vein of that spirit, works like mine kind of emerge out of that, but I think that has been done, and unfortunately, I don't know if fatwas are done digitally now. That would be something I wish someone would pick up, maybe a PhD project for someone here in the audience if you're a law student. But I do think there's a lot of amazing work on fatwa, and unfortunately, I don't go into it as much.
Right. Geeta Sagwal also made an important point, and she says digital evidence can be a double-edged sword. In the UK, where rape prosecutions and convictions are in a state of collapse, one of the reasons is the police insistence of seizing women's mobile phones. Often this is used to provide evidence of contact with the alleged perpetrator, leading to a refusal to file charges. So maybe that is something which you can take on board as well. I think that's you could incorporate that into your paper, right?
I'd have to look into it a little bit more, but thank you for that point.
Yeah. Takbir, do you want to answer to some of the feedbacks that you have received from the discussants?
Yeah. Thank you so much to all three discussants for the very extremely helpful comments. So I just wanted to address each in turn. So Professor Mannan, I think what was really useful is how you highlighted that it's a capitalist, essentially the working conditions and the aspirations of these corporations. It's this capitalist lobbying that ironically led to the creation of what could be counted as a social security mechanism, which is the financial assistance fund that got constituted under the Act. So I think that's really something I would like to explore further. But I mean, and what really I would like to highlight is that I'm not against the introduction of such a fund. I think it definitely has value and utility in the function that it serves as a social security measure. But what I really am at odds with is how it is pegged or placed as being mutually exclusive with the right to sue corporations in court. And I think that's what that's the really pernicious conflation that the Road Transport Act makes very willingly by using compensation and financial assistance interchangeably, which really dilutes the fine lines between minimal redress and accountability. With Professor Aziz Haqs, I think thank you again for your extensive comments on particularly in querying what the normative claim of my paper is. And I think that's something that I myself was trying to develop as I wrote the paper. And as someone who is a tort law activist in Bangladesh, I do recognize that tort law serves the function of both, like there's the deterrent function and the corrective function of compensatory justice, and that these may have competing or often very different objectives. And I think what I would say is that, again, I think the fund is great in fulfilling the corrective component of justice. So victims who require monetary relief in an immediate setting or without the hassles of going to court, I think that's what the fund would be very useful for. But then, having the deterrent function of law also accessible through, people like Catherine, people like Roshan Akhtar, who, wanted to hold corporations accountable for their negligent or mismanagement, which led to the loss of their spouses. I think that should also remain. And again, here comes the Road Transport Act in conflating the two and kind of positing the corrective against the deterrent. And that's what I want to challenge further, that I think these two options should remain separate. And I think here I would also probably say that constitutional litigation that has emerged, because the courts have very clearly said that the amount would never be as much as the private law claims, that these would be nominal sums. So I think the courts very much view public law compensation as being palliative in nature. So I think that, I think I would need to query further which function public law compensation serves in that framework. And with Dinapa's comments, I thank you so much for linking it to the labor conditions. That's exactly what I want to also say, that, within these protests, I think we have this tendency to vilify the transport workers as just incapable monsters who are out to kill. But, they, at the end of the day, they have families to feed. They need to feed themselves. And it's this capitalist pressure that they've found themselves in, these working conditions that are imposed. I think we really need to humanize them. So, we have to acknowledge that students were also calling for the death penalty for these workers. So, they're not out to kill. Like, they are victims of the capitalist framework as well, perhaps less deserving of the sympathy of the road crash victims, but we need to understand how labor rights violations then lead to other violations of the right to life of pedestrians. So I think I will really try to bring that much clearly as well. And I think what's really great is that Catherine, in many of her interviews, never really castigated the driver. She herself kept highlighting that the driver that, whose negligent driving killed my spouse and my friends was coming back from a 12-hour trip with only 1 hour break, and that they were paid per trip. So I think that's the kind of reality check that we need, which often we escape. And I think it goes in the favor of corporate account, like these corporations. They're happy to see their disposable transport workers getting the lion's share of the blame and being treated. So yeah, thank you so much.
Great. Thank you. Thank you those for comments. I just want to briefly say two things about your and Salwa's paper. And Sarapa might be angry with this, but having represented a lot of insurance companies, I feel that you should also focus on the fact that the amount of compensation that is being given by the insurance company is shocking, right? So I think that is something which you could also focus on. I mean, in the Catherine Masood case, Reliance just gave you 20,000 Dhaka, which is like, what, $250? So I think that is something which you need to focus on. Those are some of the issues. And I think Dina Appa made a very important point about the fact that the local transport owners, all right, it's like a mafia, right? You cannot do anything in Bangladesh, not the insurance companies, not the victims, nothing, unless and until you take care of them. So maybe those are the two important aspects: reformation of the insurance law, right? I mean, the current law, which just came out in 2018, you don't need to have insurance, right? I mean, you don't even need third-party insurance. Yeah, that is shocking, right? So those are the two things that I think you should bring into your paper, right? In respect to Salwa, I think you should also take into account the fact that, when you're having the shalish, and you said that in your presentation, right? Most of the people who are doing shalish are all the village elites, right? And most of the times they're very prejudicial already, even before they come, okay? So I think when you're actually showing the digital evidence, that makes the cases stronger. So I think you could maybe incorporate that as well, the social aspect to that, and how that could actually impact the actual shalish as well. I think that would make your paper stronger. I think we are at the end of our segment. And before I end, I'm going to take my privilege as a moderator to ask questions to the three panelists from three important perspectives. And I will ask to Professor Siddiqui first that we have completed nearly 50 years of our independence, right? And in respect to human rights issues, and today the US has given sanction to an organization 10 years late. I feel this should have been done 10 years ago. And we are also seeing some people are being brought under the sanction mechanism as well. Where do you actually see, or what should we be doing over the next maybe 10 to 15 years to make the human rights issues and gender equality issues stronger? Just a minute or two, if you.
I cannot give a general prescription, surely, right? I mean, yeah. That's a very huge, broad question. I think one thing, and it's not related to the law, it's as such, is I think we could start really rethinking what we mean by nation building and development, and not just cave into these larger global ideas of just development as growth. I mean, that's something I personally work on because I write on garment workers, but I don't know. I think for me, that's just too big a question of where, too general. You've just asked the wrong person. I do very obscure little things. I don't do grand big ideas, and I certainly don't do policy, unfortunately. So sorry.
All right,
Very
that's all right.
lame answer.
So just very
Very
general.
lame answer. I realize.
No, not at all.
I think, but the nature of the state, actually, if I really can say something, I think we really need to interrogate what the state is for and what the state is doing in all of, post-colonial South Asia, not just, I don't think the problem is just Bangladesh either. There's a larger regional question around how states operate and the kind of powers they are given, are not given. And it's interesting to think about both why Bangladesh didn't get invited to this democracy summit, which sounds like a ridiculous idea anyway, but also why it becomes important to Bangladesh. I mean, those are things we need to think about.
Okay, thank you, Professor Professor Siddiqui. Professor Hawk, do you want to give any closing comments or any feedback that you may have?
I don't have any closing thoughts. I mean, I think that at one level, having scholars like Takbir and Salwa who are focused on these quite specific problems and thinking carefully about how to move forward on them in terms of practical policy changes, which I think both papers do, is really important. The structural context in which those reforms can get implemented is probably beyond any individual capacity to alter. But without the kind of intellectual efforts that the two of you are engaged in, I think a policy is much poorer. And so I'm really glad to see this kind of work being done with such care and such diligence. So thank you for sharing it with us.
Thank you, Professor Rock. Professor Manan, would you like to say anything in closing, or?
I'm just going to echo both what Professor Huck has already said, that I think part of what sounds incredibly important to me is the type of scholarship that we see here today in these two papers, because it allows us to imagine a critical civil society and an intellectual apparatus that can ask difficult questions, and have a sense of how to think through alternatives. And I guess my personal, I would stand next to what Professor Siddiqui said, which is the nation really the answer to much of what ails us? I'm not convinced from the perspective I hold, obviously as someone who studies the pre-modern world, but who's a citizen of Pakistan. The nation is not something that I can see, the state is not something that I can see giving us emancipatory and restorative futures, which we desperately need. But we're not going to get there without the type of careful work that we see here today either. So I think we need both of that. We need our skepticism, and we need the careful, critical engagement that we see on display here. So thank you from me as well for asking me to join this panel. Great. I appreciate it.
Thank you, Professor Manan, Professor Hawk, and Professor Siddiqui for your time. It's really midnight in the US. Extremely grateful for your patience. And I think this was definitely going to encourage the young scholars who have participated in the conference, and I'm sure they'll be greatly benefited from the feedback and the comments that you have given. I want to thank SAILS, I want to thank BLAST, and also the University of Asia Pacific for helping us organize this program. And I want to thank all the two presenters. I think they have done a wonderful job in this regard, and hopefully in the future, or probably in the next year, we would like to do a similar conference, and hope we can get more interesting feedback as well. So thank you, everyone. Good afternoon, and also good night to everyone, and hope everyone have a good night and good day. Thank you.
Thank you so much. Thank you.